From the opinion pages of the Wall Street Journal, this is Potomac Watch.
Welcome back. I'm Paul Gigot here with Kim Strassel and Kyle Peterson talking about the new Supreme Court term, which starts today and could be a doozy. Kyle, just on to elaborate another point about the affirmative action case, racial preferences case involving Harvard and North Carolina. Where do you think Chief Justice Roberts is going to come out here? He's been very strong and clear in the past on these racial cases. He said famously once, if you want to stop discriminating by race, stop discriminating by race. I think I'm paraphrasing that. It's not the exact quote, but that's the essence of it. He did, as Kim said, call dividing us by race a sordid business. And yet to do that, he is going to court. If the court goes there, say in a 6-3 ruling, the left will come down very, very hard against them. And there'll be all kinds of accusations that it's acting in its own racially biased manner.
Well, my guess is that he is going to stick with the conservatives and Clarence Thomas on this one. And I say that for exactly the reason that you suggest. I mean, Chief Justice Roberts gets a lot of criticism for being an institutionalist and hedging his decisions seemingly sometimes to protect what he sees as the legitimacy of the court against critics that are raising that question. But there are a couple places that he has been very strong. One of them is religious liberty, and the other one is on these questions of racial preferences, racial sorting. He has, as you say, laid out his opposition to that in no uncertain terms. The other thing that I think is important to remember is that we have a 6-3 conservative court now. And so the question for Chief Justice Roberts is not always whether he's going to decide the case. He's not the swing vote anymore necessarily. The question for him is often, am I going to side with the majority or am I going to side with the dissenters, which allows Clarence Thomas to decide who gets to write the opinion for the majority? And here's a case where you can imagine Clarence Thomas writing a very critical, very sweeping opinion on racial preferences. And even if you assume that the Chief Justice, what he wants to do is hedge it a little bit, he's worried about the court perceptions of the court, you would think that that would still militate towards siding with the conservatives if he wants to be the one who writes the opinion the way he wants the opinion to be written.
All right. I tend to think you're right. I think this will go against Harvard, but it's going to be fascinating to watch. I think this is one of the most important cases of the term, and arguably maybe the most important case in a long time, because the American balkanization by race has really taken off of late and I think has pernicious impact across so many parts of American society and is very, very dangerous indeed. And the court can send us a major message that this kind of behavior is unconstitutional. All right, we got some other cases. One you guys can pick the ones you like, but one I like is this dispute that's coming up fairly quickly on the docket over the extent to which California can regulate interstate commerce. It's a particular challenge to California's Proposition 12, which requires that all pork, veal, and eggs sold in California comply with very strict limits on how the animals can be confined. And this is, of course, because of California's market deemed to affect business across the 50 states, Kim, and that has major implications for federalism.
Yeah, I'm watching that one really closely because one of the problems here as well, too, is sometimes if you just had a state that decided it was going to try to assert this sort of authority, people would just ignore it. The problem, particularly here with California, is it amounts to such an enormous part of the American economy all on its own, given its size, that often when it lays out some of these standards, it can single-handedly require entire industries to change their behavior because they can't risk losing out on the entire California market. And so having some sort of say-so over all of this and what the limits of that or single-handed ability of California to redefine industries across the United States, I think is very important. Another one I'm looking at, and it's not getting nearly the attention of the affirmative action cases that you just mentioned, but it's also very important for the same reason you mentioned, Paul, because it gets to questions of racial considerations. But this is a case that will be heard in November. It's called Holland v. Brackeen, and it goes to the question of the constitutionality of the Indian Child Welfare Act of 1978, which is a law that makes it much harder for non-Native parents to adopt Native children. And this does have to do with some kind of horrible history with regards to how Native children were handled in the past. But now, in our kind of more modern times, this situation has become one in which there really are a lot of decisions that are being made solely on the basis of race in ways that are excluding some Americans from their ability to adopt. And so I'm looking forward to seeing that. That's going to be in November.
Kyle, any last case you want to highlight here?
I'll put in a plug for Moore v. Harper, which is another election case, this one out of North Carolina, also involving gerrymandering. And what happened here is that the legislature passed a redistricting plan, and the state Supreme Court threw it out, citing the state constitution. But what's notable is that the state constitution doesn't say anything, actually, about gerrymandering. The state Supreme Court was using some language, really general language, about guaranteeing free and fair elections in North Carolina and saying on that basis they were going to invalidate this redistricting plan. And so now, again, this is back up at the U.S. Supreme Court. And there's some interesting questions about how the court would intend to rectify this situation, because generally state Supreme Courts are held to be the final word on state law. But of course, if you look at the U.S. Constitution, in the Elections Clause, it says that state legislatures have the ability to set the manners of holding elections. So that's what the plaintiffs in North Carolina is counting on here. And it will be another fascinating case to watch. I think a lot of the commentary on it, if people have heard of this case, is way overblown. There are a lot of analysts who haven't really looked closely at the details, saying that if North Carolina wins here, then any state after a presidential election could just say, we're going to directly appoint our electors and thumb our noses at the voters in the popular vote. I don't think that's accurate at all. And so I would discount a lot of the commentary you're hearing about this case, but nevertheless, it's going to be an interesting one to watch. And I'm really looking forward to the oral arguments here.
We're going to step back a bit here just for a couple of minutes and talk about the attacks on the court. We have Elena Kagan, one of the liberal justices, now in the majority in a lot of these hot-button cases. Here's what she had to say a couple of weeks ago.
The court shouldn't be like wandering around, just inserting itself into every hot-button issue in America. And it especially, shouldn't be doing that in a way that reflects one ideology or one set of political views over another.
Well, that was widely interpreted as a shot at the current majority in the wake of its opinion ruling last year in the Dobbs case, overturning Roe v. Wade. I think she's basically warning the justices that they're on notice and they're going to continue to court criticism from the progressive left if they continue to do this. And indeed, she's basically joining the chorus, albeit in a more subtle fashion, that you hear that the court runs the risk of becoming illegitimate. You read it everywhere in the Democratic media these days, and they're often citing polls saying that the Supreme Court is not popular, and now it's less popular than it was. But of course, when you get that much criticism, that's not surprising that so many Democrats are finding it, saying they don't like the court, Kim.
Right. And, just a few more things that she said there. She complained or suggested that courts were becoming extensions of the political process, and that made people see them as extensions of the political process. She said that courts needed to do more things that were recognizably law-like, which is a bit of a joke, given that if you look at the opinions, even the very controversial opinions that the Supreme Court issued last year, they're evidently law-like. They're quite long on the law, most of them, and they were attempting to, as we were just discussing with some of the cases this term, clear up some longstanding legal questions. But when you have even someone like Elena Kagan, who she probably considers herself an institutionalist, but nonetheless taking shots at the court, you get all of the press on board. We have a Washington Post headline out saying Supreme Court term begins amid questions about its legitimacy. You have legal scholars like Larry Tribe who complained this summer that the Supreme Court was installing, quote, the tyranny of the minority. When this is all you see in the headlines all the time, instead of the simple recognition that this court has issued some legal opinions that people might disagree with, but just because they don't disagree, it doesn't make the court any less legitimate. When this is all you hear, no surprise whatsoever that there are growing numbers of Americans who then believe that there's something wrong.
Yeah, and we should add that even despite the so-called conservative majority, conservatives, so-called, who have these policy preferences don't always win. The most recent famous case example of that was the Bostock case involving LGBTQ rights. So this conservative majority is hardly monolithic. There's differences in terms of emphasis, differences on federalism, differences on a variety of subjects. Yes, they seem to be united on religious liberty. They're certainly making inroads against the administrative state, but I would argue that that has long been called for, given the rights of Congress and the Constitution, the power and authority of Congress, which they have ceded too often to the executive branch and the regulators. So it's going to be fascinating to see how much the court moves on so many of these areas. It's in many ways not the worst functioning part of the U.S. government, the best functioning part of the U.S. government, because it's now cleaning up some of the messes it has made, and it is going to be fascinating to watch as it unfolds. I want to thank Kyle Peterson. Thanks, Kim Strasso. Thank you all for listening. We'll be back with another edition of Potomac Watch, as we are every day. Thanks for listening.